Hello, this is John Walter with Southeast Advocate. I'm a lawyer licensed in Alabama, Georgia, and Florida, and I just wanted to speak with you for a moment to talk about a common question that people have, which is how attorneys get paid and the best way to pay them. And the answer really depends on the type of case that you have. So there's 4 different ways that lawyers get paid, and which one will apply in your instance depends on a few simple factors. So if it's a defense lawyer, if you're being sued, then most likely the lawyer is going to charge by the hour. Or if it's a case where you're a plaintiff but it's not a large amount in dispute, then the lawyer will charge by the hour. And similar with maybe like divorce proceedings and things like that. The way that usually works is that the lawyer will require a retainer. Back when I was working as a defense lawyer, it would be a $5,000 retainer prior to the case actually entering into litigation. So before a lawsuit is filed. If it's after the lawsuit is filed, $10,000, just because it's much more, you're certain that you're going to be running a long race with that client, so you want a larger retainer. And then you would charge an hourly rate. As a defense lawyer, I would charge $3.50 an hour, and still today, if anyone asks me to do something by the hour, it's $3.50. And I would hold that retainer in a trust account, and you bill the client, by each hour you're working, keep in 6-minute increments, so 1/10 of an hour, and then at the end of the month you send the bill, and even though you have this amount in retainer, they still owe whatever amount I billed. And so you just hold that amount in retainer just to make sure you get paid. You don't do work for free. So that's how it usually works on the defense side. For plaintiffs, it's very different. Especially if it's a high value case, then lawyers are eager to work on these cases on a contingency fee basis, which means you only pay the lawyer if they actually win the case. And so, or it's settled. And so you only pay if money is received by the lawyer, and the amount of percentage that the lawyer will receive will depend on really the state and what's normal in that state and the complexity of the case. So for example, in Florida, it is a requirement that you cannot go above 1/3 of the total fees awarded to the plaintiff. So no more than 1/3 of what the plaintiff receives in either a settlement or a verdict can go to the lawyer. In Alabama, there is no such restriction. So I've heard of lawyers sometimes charging as high as 50%. And the only standard in Alabama is as to whether or not it is reasonable under the circumstances. So you can argue that 50% is reasonable if it's a very challenging case and high likelihood of losing, and so the lawyer wants to be compensated for the additional risk they are taking in investing their time and resources into the case. And then also, if it's just a low value case, then they might want a higher percentage. I personally try to shy away from going above 1/3 because that's the standard in Florida, and I think it's in most cases pretty standard and reasonable. But I understand there are circumstances where I would not want to take a case at 1/3 because the compensation would not be sufficient to make it worthwhile for the attorney, and so by allowing them to charge up to 50%, that allows the attorney to work on the case and justice to be served, and even though it's a very large amount, otherwise a lawyer might not take the case because it would not be worthwhile. So that's how billing by the hour and then contingency fee, that's how those two work. Now there's another one that's less common, but it occurs frequently. It's a fee shifting statute, either under federal law or state law. A lawyer will represent a plaintiff and will be taking hourly records as if they're billing by the hour. But once the case is completed, there is a federal law or a state statute that will say that the defendant, the person being sued, the person who caused the harm, is the one who needs to pay the plaintiff's attorney fees. And so an example of this type of case is a wage and hour violation. That's the federal law that is passed to protect workers. And so if a worker is forced to work off the clock, for example, or they are not paid their overtime wages that they are owed, then the amount that the individual worker might be owed can only be a few $1,000s. And it would not be worthwhile for a lawyer to take that case on a contingency fee basis. And it also would not be worthwhile for the worker to pay a lawyer by the hour, because that amount would exceed the amount they're owed by their employer. So federal law steps in and says, no, lawyer, you go ahead and work on this case, you bill by the hour, and we will make sure you get paid. The defendant will end up having to pay those attorney's fees. And so that's another arrangement that works. And then finally, just a flat fee basis. There's certain types of work that lawyers do that lend themselves well to flat fees. This might involve, if you want to create an LLC or a corporation or simple routine transactions, you do not see many flat fees in the litigation scenario. Sometimes you'll have very large corporate defendants that will hire an attorney on a flat fee basis. They'll pay them, say, $500,000 to represent them in all of their cases year round. And so that's regardless of the volume. So the volume will fluctuate, but that's their go-to lawyer. You'll see that occasionally, but it's very, very rare that a private individual will hire, rare, it might even be unheard of, that a private individual would hire a lawyer on a flat fee basis if it's litigation. But transactional, yeah, that happens. If it's a business transaction, maybe contracts you need help with or incorporating. But anyhow, I hope this is helpful in answering your questions. If you have any more questions about that, you can leave it in the comments and I'll try to reply.